Here's a headline that's kind of surprising. This from the Globe and Mail online. This wasn't in the paper this morning, I don't believe. U.S. High Court finds fault with Conrad Black fraud conviction, questions jury instructions, and sends case back to appeal court for review. Could Black be wiggling out of prison? Well, Edward Prutschi, criminal lawyer, Adler, Batensky, and Prutschi joins me now. Hi, how you doing?
Good morning. Very good, thanks, Jerry.
Always good to talk to you.
You too.
So my understanding here is this all comes down to the court interpreting two words, honest services, correct?
Right. I mean, it's a little bit broader than that because the honest services provisions of the U.S. Code there have been utilized in very broad-reaching sort of antitrust and fraud cases all across the board. So those two words have caused all sorts of consternation for a whole host of high-profile people and others in various cases over the years.
Like Jeffrey Skilling from Enron would be another one?
Right.
Yeah. Oh, okay. So what's the thumbnail interpretation here that those of us without a law degree could understand that means, honest services?
Well, it's actually not that straightforward, even for those of us who do have law degrees, and that's why it's gone up to the Supreme Court for clarification. But what these provisions in the U.S. permitted was the creation of an offense, arguably, and it was different depending on which state you were in and how their particular state Supreme Court interpreted it, but where even though there wasn't any underlying criminal offense, if a person failed to provide honest services either to the public or if they had a fiduciary contractual relationship with someone else and there was material financial loss, that in and of itself could create grounds for a fraud. So this honest services provision has been applied in a number of cases, including Conrad Black's, to imply that even though there wasn't any specific statute that was violated, and even though we may not be able to demonstrate a fraud per se under the criminal code, the fact is that you didn't deal with the people who you had an obligation to deal with in an honest fashion, and because of that, we can link you to a fraud and in fact, found a conviction on fraud.
It sounds to me like you could be in jeopardy, not because you're dishonest, but because you're inept.
Ineptitude would be part of it. I think more what it seems to create is criminal liability for something that in Canada would largely be civil. So in a circumstance where somebody might be overly sharp in contract negotiations, request things in return that perhaps they weren't entitled to, materially hide certain things that they ought to have disclosed, all of which can give rise to civil liability on that contract or on that relationship. In the U.S., arguably, you can actually find yourself in criminal court and ultimately in jail for it.
So the U.S. Supreme Court, as it's characterized in the Globe and Mail, handed Conrad Black a slight opening to win reversal of his fraud conviction. Is this the same case going all the way up to the Supreme Court, or is this an opportunity now to say, well, we're changing a definition, so we're going to bring our case back?
Well, it's a very small opening with respect to Conrad Black specifically. It could have much more far-reaching impact on future cases in the U.S., but basically what it's done for Conrad Black is relative to his series of convictions, it opens a door on the actual fraud charges. And what happened to Mr. Black ultimately is that he's found guilty both of an obstruct justice for the now infamous photo of him staring into the security cameras and removing boxes from the Hollinger offices, and then a series of frauds. And the sentences were actually divided out. So there was a 6.5-year sentence imposed for the obstruct justice, and then 3 years on 3 separate frauds. Now, all of those are being served concurrently, so really only the longest one ultimately matters in terms of determining how much time he actually spends in jail, and that's the obstruct. So the honest services provision has no impact on the obstruct, and looking very briefly as this news is just breaking, I have some doubt as to whether or not it's going to have any impact on Lord Black's actual release from prison. Because
the more serious one, and much more easy for all of us to understand, is obstruction of justice.
That's right.
So he's going to sit in jail for a little while. Here's something I don't get. I don't get this concept of serving sentences concurrently. What's the point of charging people on a number of offenses if they're actually effectively only going to serve one?
Well, that's actually very common both in Canada and the U.S.
I know it is, but I don't understand it.
All of these charges relate to a single transaction. So a single incident involves all the same people and ultimately all the same victims. It's not uncommon for a judge to say, I need to take totality into account and say here, all of these sentences ought to be served together, but for the purposes of sort of sending a message and, frankly, for the purposes of these types of appeals, I need to set out how much I thought was appropriate under each sentence. But you don't take somebody who, in the course of one action or series of actions, has defrauded, say, 5 different people and say that because of that, it's a 1-year fraud, but it's actually multiplied by 5, and now all of a sudden they're doing a 5-year sentence on what really was a single incident.
All right. In the case of violent crimes, sometimes then they are what do you call it when it's one after another?
So it would be a consecutive as opposed to concurrent sentence. And that does happen if you have multiple victims in arguably separate incidents. So if a person is involved in a crime spree and it affects multiple people on different days, for example, and it's particularly egregious, you may find a judge accept the argument that they ought to be applied consecutively as opposed to concurrently.
Yeah, and despite how all of this goes, it's my understanding that Conrad Black does not believe that he broke the law.
Oh, there's no doubt. I mean, he's made that abundantly clear over and over and over again, both at the trial and since then in his many writings and his public comments. He doesn't feel that he's done anything wrong, although this particular appeal I don't think is going to get him to the point where he has complete vindication, which is, of course, what he wants. What he will be able to say potentially is that he has sort of knocked off yet another piece of the prosecution's case, because there's no question that what the prosecution started with was substantially more than what he ultimately was convicted of, considerably more. So even what he's now been found guilty of is a relatively small component of what was this massive fraud that the prosecution originally alleged, and now it looks like another plank is potentially being pulled out from under them. Whether that actually means Conrad Black leaves jail in Florida anytime sooner, I doubt, but I guess it's a small victory from his perspective.
Yeah, well, it may be something useful to cases like this going forward in the United States, and if nothing else, some sort of moral victory from which Conrad Black can write 10 or 15 columns.
Absolutely. You can expect that you'll see him put pen to paper on this very shortly.
Edward Prutschi, criminal lawyer, Adler, Botensky, and Prutschi. Always good to talk to you.
Take care, Jerry.
Thank you very much.